You're on it. Thank you. All right. Good morning, everybody. So this is day 1 of week 10, right? We're going to be working on module 2, lesson 2, which is judicial activism versus judicial restraint. So what are those two? And we're going to directly talk about those in question number 4 on our notebook today. All right. So the judicial system, so meaning the courts, what does judicial activism look like versus what does judicial restraint look like? All right. So in this week, we're going to work on our notebook. We'll have the assessment that goes with it. And then we are going to start our Supreme Court case project. So all of these dealing with the judicial system. Okay. So the notebook going over the key facts and parts of our lesson, the assessment, testing your knowledge and what did you learn? And then the Supreme Court case project, making sure that we're applying that understanding of activism and restraint. Okay. Looking at court cases and doing your own interpretation. All right. So we'll start this today and then we'll work on this more in day 2. Couple of housekeepings. Okay, so in Canvas, your grade is going to show as 0, and that's because we switched from quarter 1 to quarter 2. Okay, so last week it showed your quarter 1 grade. Now that we're in quarter 2, it resets. Okay, so if you have not turned in last week's work, because remember module 3, lesson 1, those were the first grades that were going in for quarter 2. I graded everything yesterday. I'll grade more today. So if you have not turned those in, you're going to show a 0. Now, that doesn't mean that that was your quarter 1 grade. That's quarter 2 because it officially started yesterday, or starting yesterday today. All right. So if you haven't gotten in those first assignments, that was module 3, lesson 1 notebook and module 3, lesson 1 quiz, right? The 2 things we did last week that apply to this week. All right. And then everything we do this week will be going forward, will be in quarter 2. To see your final grade, your quarter 1 grade, that's going to be an Infinite Campus. All right. So if you didn't check last week, go check this week. That'll be an Infinite Campus. I sent an email about it explaining. If it's showing a 50% and you're like, that's not what I got, that's because it's the minimum F, right? So the minimum F only applies, the minimum 50% only applies now to quarter and semester grades. So you get what you get on assignments, assessments, right? You get what you earn, okay? If at the end of the quarter it's less than 50%, then you're bumped to a 50%, not above that. Okay. Any questions on final grades or anything like that? So in Canvas, if it's showing a 0, that's because you haven't turned in last week's assignments. Okay. Turn those in, it'll bump right up. That's just reflecting quarter 2. Okay. Quarter 1, because I went in and I changed the percentages. So we're instead of quarter 1 summative and formative, now we're in quarter 2 summative formative, right? And obviously the more assignments we add, then that helps average that. But if you turned in your work from last week, you did decent, you should have an A. If not, then get those in and it'll bump that 0 up really, really quick. Okay. And the announcements, check announcements for college app, FAFSA help and stuff. I've got a couple I need to post this week, so I'll get those in. The CSN Promise Scholarship and stuff. Take a look at this. This is great. Community college. There's just so many things you can pursue through community college. AC repair, pilot, welder, builder, cook, hotel event planning, pastry chef, concierge, vet tech, dental assistant, first part of nursing, sonogrammer, police, paramedic, firefighter, CSI. Like there's so many things you can do going through community college. Okay. So much cheaper, less expensive. And often they have a real flexibility with classes. I worked while I went to school, and stuff. So I was able to kind of juggle. I worked about 20 hours a week and then would usually take 4 or 5 classes. So I was busy for sure. And stuff, but getting those credits done before I went to university, and it was a lot cheaper. So I really encourage you to look into that. All right, if you, I know we haven't gone over tons of court cases. We're going to go over more this week and stuff. We went over a few. What court case can you maybe think of that has had an impact on your life? Can you think of any court cases from the Supreme Court lately or in the last couple of years? And stuff that maybe you feel has affected you or that you paid attention to, or in history, maybe a Supreme Court case that you feel like had a big impact on our lives. I always think of, because we're in the classroom, I always think of Brown versus Board of Education. Does anybody know what Brown versus Board of Education did? Probably one of the most well-known Supreme Court cases, especially from the Civil Rights Movement. Anybody? When I think of impact on daily lives and I think of teaching in the classroom, Brown versus Board of Education is always one that I think of. Does anybody know what Brown versus Board of Education did? I'll give you a hint. Separate but equal. Or is it? Clue. No one? Brown versus Board of Education? So they argued so Brown versus Board of Education was a ground mark court case. And we'll talk more about it in this chapter or in this lesson, in that it led to desegregation of schools. So segregation was built on the idea of separate but equal. And Brown versus Board of Education argued, no, anytime you are separating people based on race or gender or things like that, they are not equal. Yes, yes. So segregation, yes. So so desegregating schools. So Brown versus Board of Education was the beginning of desegregating schools. My mom is 62, 63, and she grew up in Louisiana. And so I've talked to her a few times. She was right in that pocket of time when they started desegregating schools in the 70s. So she talks about her high school, and she ended up switching high schools and stuff, and going through the desegregation process and what it was like attending school at that time, especially in the South, and stuff. So it's really interesting hearing. So maybe your grandparents, ask them about that. If they went to school in the 60s, 70s, they probably experienced desegregation, because it kind of happened at different rates in different states. But that definitely, when I think of education and being a teacher, I think that has a huge impact, obviously, that maybe you and I aren't even, it's easy for us to take for granted, what yet really, like my parents or your grandparents, this was a big change in education for the better, right? Truly making us equal, okay? That everyone should have equal access, and we're not discriminating and dividing people based on race or ethnicity. Okay. All right. I saw this. I thought this was cute, and my husband felt it was very accurate of the looks that I give. So you can tell me thumbs up if you think this is accurate that I give these looks, or thumbs down if you think I always have a smile on my face and I would never, ever, ever show these looks. But I thought it was kind of funny. All right. So I know I've showed a few that like pick on students. So of course, we got to be fair, and we'll pick on teachers. All right. So I'm always patient and approachable as a teacher. Also me as a teacher. He says I eye roll a lot. He says, like, I'll give a look, or I'll be like, I won't say it, but I'll be like, I'm a smile. That's nice. I know, but I'm sure there are times when I can be like, so I thought that was pretty funny. So stuff when I'm annoyed, or I'm like, I just went over that. So I know for sure that I do give an eye roll when I just went over something and somebody's like, wait, what are we doing? And I'm like, oh my goodness, for the love, right? So yeah, good time. It's good time. Maybe I get away with it more because my tile, right? This is projecting into my little tile, so I can slip them in there and nobody sees them. So, but I thought that was kind of funny. So my husband said it was accurate. So I was like, probably. All right. So getting into our lesson, go ahead and get Canvas open. We're going to jump right in. All right. Our learning intention for this week. So what we're working on and our goal to accomplish and demonstrate, all right, is what does equality under the law look like by examining the courts and how they've interpreted the Constitution over time. So there's different ways to interpret the Constitution. There's activism interpretation, and then there is restraint. Activism tends to take a more modern approach. Like, okay, yeah, the document was written in the 1780s, but we want to look at it from today's perspective. So more interpret it. Judicial restraint is going to be more interpreting the Constitution for literally what it is. Okay, so we're going to look at different court cases or ideas or philosophies of which is the best way to interpret, or does it maybe depend, right? Maybe it depends on the topic, or it depends on the issue. Sometimes maybe we need to show restraint. Sometimes maybe we need to show activism, or maybe you're all restraint or all activism. Again, just like anything, there's going to be a lot of different opinions on this. Okay. So we're going to jump into the notebook, all right, which has the rubrics. We're going to go over the supporting question, the key vocab, and we'll look at judicial decision, so how that can be activism or restraint, and then look at what is the difference between activism and restraint. Okay, so that's the goal, is to get through the first 4 today. All right, so we're going to jump into Canvas. Okay, so 2 things really quick. I just posted this in Canvas. The notebook, we are going to get rid of 8 and 9, so when we open it, I'll have you delete those, and that's because we're doing a project this week, so I'm shortening it a little bit so we can get it done in class, and then you can focus more on the court case project. All right. I'm going to go over the court case project, the Supreme Court case project, tomorrow. And there's a PowerPoint I'm going to use with instructions. I'll give it to you in the chat tomorrow, but I'm also posting it here. And again, it'll have those specific instructions step by step by step, just like I did with the superhero project. Okay, so that's there in the announcements. Let's go into modules, and we're going to go to module 3, lesson 2. Again, as always, remember, you can go to the live session page for this week. It has the review sheet, PowerPoints, and then this is where I post videos, right, for class. So super helpful when you're trying to catch up or if you need to review something. So really quick from last week, right, the notebook and the quiz, they're technically both due today, all right? But if you haven't, get them in. We did the entire notebook in class and the quiz. All right, so are we reviewed for the quiz, right? You have to take the quiz. So please get those in. That's a great way to get your grade up, okay? So to get your grade, start out on a really good foot for second quarter. So we're going to be in module 2, lesson 3, judicial activism versus judicial restraint. Let's go to the overview page. So again, looking at those learning intentions, we're going to evaluate how students use the Constitution to influence and fight for civil rights and liberties, and examine how the courts interpret the Constitution over time. Are they using activism or are they using restraint? Are they trying to take a more modern interpretive approach, or are they being more literal? Like, it literally says this, so that's what we're going to do. And it will often depend on the judge or the person who's hearing the case. All right, let's open up our notebook. So go ahead and click on that link, make a copy. Once you have it open, we're going to save that to the Google Drive. Okay, so you're going to save that to your government folder. Always a good idea. Looks like I need to save mine to my proper folder, so I'll do that. You save yours to your government folder. My week 10. Move. Okay. Oh, it's there, so I don't know why it's being off. Okay, so save it to your government folder. And then remember to make it shareable. So that's anyone with the link, okay? And that way, when you submit it, I can grade it, okay? How are we doing? Give me a thumbs up. You've got Canvas open, you got your notebook open. Awesome, awesome. Okay, so we're gonna go back over into Canvas and let's find our essential question, supporting question. So how would the framers interpret the Constitution today? This is a very loaded question, you know, and the reality is that it's probably going to depend on which person, you know, and what court case. Okay, so you're going to copy and paste and put that here in number 1. I'll put this in the chat for you. How would the framers interpret the Constitution today? And we'll look at some example of court cases where maybe the way they interpreted the Constitution in the 1800s is different than they interpreted in the 1900s. And actually, we'll look at the Brown versus Board of Education, desegregation of schools, the original court case that said separate but equal, and then the follow-up court case that overturned a previous court case. And it's all depending on how they interpret the Constitution, using judicial activism, judicial restraint. Okay, there are going to be 5 key vocab words, so let's go over those. So, foe, this divide has established the creation of political parties, factions, or political foes, so opponents. Capital, under the state law of Florida, the only time the courts can appoint counsel to represent the defendant is when that person is charged with a capital offense. So capital meaning like, you know, very, very bad. Appraisal, assert denial or the due process is to be tested by an appraisal of the totality of the facts in a given case. So appraisal is to take all the facts of a case into consideration and to kind of appraise the situation. Is there enough to charge someone? Is there not enough to charge someone? The value or the merit of the accusation or the situation. Is it meritless? Is there no evidence? Or is there an argument? Is there evidence to support the argument? Admonition. So the 6th Amendment stands as a constant admonition that if the constitutional safeguards it provides be listed, justice will not still be done. And then contemporary landmark cases are often the result of courts making decisions that use a broad or flexible interpretation of the Constitution or reinterpret guiding principles of the Constitution, reflecting a contemporary society. So it would be more of an activism approach, okay? Taking it and kind of looking at the theme or interpretation of it, not necessarily the literal interpretation of it. All right, so let's jump over to our notebook, and I'll put these in the chat. Okay, so foe, and that's to have enemies or rivals. And again, please stick with me. We're doing this pretty quick today because we are trying to get a little bit further than normal so that tomorrow we have more time to work on the Supreme Court case project. Okay, capital offense. So a serious or death penalty case. So some of the worst cases. So usually that would be like murder or some offense where you could potentially face, oops, it didn't copy it. All right, let's try that again. Control-C. Yeah, where you face death penalty or treason or some very, very serious, you know, terrorism, some very, very serious offense. Okay. Appraisal is, you know, look into, reading of, you know, is there precedence? Is there a case? Like pouring milk in before cereal. Yes, a little bit, yeah. Okay, so this is the third one. The Sixth Amendment stands for the constant, so it's a warning, admonition. So again, you should be putting these into your chart, please. So it's a warning. And then finally, contemporary. When courts use a more flexible or broad approach to interpretation of the Constitution, then oftentimes they will institute a new policy or change a pre-existing policy or law that might be considered groundbreaking. So contemporary, meaning modern or progressive, you know, moving ahead of the times. Current, that's a good way of saying it, current. Okay, so I'll give you a minute. Finish that. We're going to jump back over into Canvas, and we're going to go to the next page. Oh, the sun is coming through like at just the wrong angle, really bright. Although the United States is governed by the Constitution, there are many aspects of the law that cannot be understood simply by reading the document. The U.S. Constitution, therefore, needs to be continually interpreted as it is implied to concrete situations, okay? There are numerous methods for interpreting the Constitution, which legal scholars and justice advocates, tried to do this. Most interpreters of the Constitution begin by looking at the language of the document based on their opinion on textual interpretation. Textual interpretation can be difficult as it examines not only what the Constitution says, but also what it does not say. So sometimes what it says is just important what it does not say, okay? So how we interpret. So for example, maybe what we consider cruel and unusual, so this is a good one. For example, what we consider cruel and unusual punishment in 1789, how would the framers view cruel and unusual punishment today? Back then, the death penalty was very common. It wasn't even really controversial. Like most places had the death penalty. Today, a lot of states don't have the death penalty. So what we consider cruel and unusual punishment, over time, as a society, as our morals and values change or kind of trends change, what was interpreted as cruel and unusual, sometimes the way we define something has to be updated or modernized, right? Depending on how we define it today. So that would be a great example of what is cruel and unusual. Well, 100 years ago or 200 years ago versus today, we're probably going to have very different interpretations of that. Okay, let's take a look at the checking for understanding, and then we'll do the questions. To interpret laws based on precedent means to, and that's to look and rely on previous or similar court cases. So sometimes with interpretation, what will happen is not just looking at what the Constitution says or doesn't say, but look at other court cases that are similar to your case and how did they interpret the Constitution. So you want to try to stick with pattern. So you want to try to be consistent, right? That we're honoring the Constitution in the document. So how did another court case interpret it? And can that be applied, or can I borrow from that when looking at a current court case? Once a decision has been made about the means of a law or part of the Constitution, the decision will stand until, let me see, the interpretation will usually stay in effect until the law or the Constitution is changed. So yes, once a court case comes down, whether we like it or not, that interpretation stands until the Constitution is either one, amended, which is very hard to do, but it does happen, or another court case comes along that overturns that or reverses that. So once a court decision is made, it really does stand until one of two things happen: amending of the Constitution or another court case that rules differently than that court case dealing with the same topic. Okay. So what is constitutional interpretation? So how the courts look at actions and branches of the state in relation to the reading of the Constitution and what they think the founding fathers meant. So basically it's like trying to be a mind reader 240 years later. You know, what did they mean? What was their intent with what they wrote? How does that word interpreted then, and how do we interpret it now? Is it interpreted differently? Sometimes over time, the meaning of a word can change, or the way we view a word can change. And stuff. So I'll give an example, the term gay. So like in the early 1900s, if you watch old movies, they use the term gay to refer to like happy, joyful, like outgoing. Now, obviously that term, I don't know anybody that uses it to reflect happiness or something like that. They use it as a reference to sexual orientation, right? So sometimes the way we interpret terms, you have to look at the time in which it was said and how did they interpret it. So if the founding fathers are using a certain term, how did they interpret it versus how do we interpret it? That can be really important. Context can be really important as well. Can you think of any other terms maybe over time where it was seen as one way and then over time, same word, but different interpretation? Why is the interpretation of the Constitution important? Because lawmakers and actions can either uphold or strike down, say strike or strike down based on how the courts interpret and the Constitution is used. Anybody think of any other terms that, like, over time, depending on where in time you're using that term, there's a lot of different ways, or not a lot of different ways, but maybe very stark different ways that that term could be used or interpreted. So same with the Constitution. Sometimes verbiage matters, and what did it mean when they wrote the Constitution versus what does it mean today? And are we interpreting it correctly? Or how do we, if they are different interpretations, how do we bridge that gap? Okay, give me a thumbs up if you have 1 through 3 done. You're with me? Okay, so the next thing we're going to look at is we are going to look at, and this is where we'll end today, okay, is activism versus restraint. Judicial activism is often used, when people are more broad or interpretive with the Constitution, okay? So using today's standards to interpret the Constitution. So often they're flexible, they're not literal, okay? When we see people who use judicial restraint, okay, they're going to be probably more literal. They're going to probably be more like, this is exactly what it says, so I'm going to follow it to the letter of the term. So more literal with their interpretation. So some examples, Brown versus Board of Education that I mentioned at the beginning of class, that was definitely a judicial activism case, all right, where taking the verbiage of the Constitution and taking it more and interpreting it or being flexible with it, okay, versus Plessy versus Ferguson, which approved the separate but equal doctrine, okay, and took a more literal approach. So same issue of dealing with segregation. One took a restraint approach, okay, which was the Plessy versus Ferguson, so using literal interpretation. And then Brown versus Board of Education, dealing specifically with segregation within schools. So it said took a more activism approach interpreting, okay? So going into the 14th Amendment and therefore justifying a change of that ruling, okay? Saying, well, based on this amendment, this is how we should be interpreting the Constitution now, not based on the original Constitution. So amendments to the Constitution change the Constitution. And Brown versus Board of Education said, well, maybe this was originally how it was written, but with the 14th Amendment after the Civil War, this is the new way in which we should be interpreting the Constitution. So therefore, separate is not equal. Where the earlier ruling in 1896 took the restraint approach of the original Constitution, not the 14th Amendment, Plessy versus Ferguson, and said, well, if they can be separate, people can be segregated or separate as long as they're treated equally or they have, and obviously that was not the case. But again, the way that courts are interpreting. Okay, so great example of where judicial activism was used versus judicial restraint. Okay, so I want to do a quick little video and then we will answer number 4 before we end class today. All right. Talks about judicial activism versus
what
judicial.
What we're going to do in this video is talk about the terms judicial activism and judicial restraint. In many videos, we have talked about it can say that an executive action, say a rule or regulation or an executive order, is unconstitutional. But as it's doing that, as it's exercising its judicial review, how does it go about doing that? And this term judicial activism was first introduced by Arthur Schlesinger, who we've talked about in other videos. And it's meant to imply a judiciary that is not strictly just ruling based on maybe what the Constitution says, but also their own personal ideas. So personal views. It sometimes has an implication that the judges are overreaching in some way. Some people might say it, and this would be a little bit of a negative, legislating from the bench, legislating from the bench. And you'll often hear that, hey, that judge or that court is legislating from the bench, from the people who don't like their ruling. They're saying, hey, they're not strictly looking at the law. They're trying to make their own laws through their rulings. Now, some would say that it's necessary for the judicial to do this because they are interpreting the Constitution in the world as it is, and the world that we are in changes over time. So it is really a form of positive activism, that they are defending liberties, that they're defending rights, especially in the social context that we're in. I'll leave you to decide whether you think this is a good idea or not. Now, judicial restraint is the opposite of it. This is a situation where the judges or the courts limit their power. So limit their own power. Where they say, hey, look, our job is to just be the umpire, the referee. Our job is not to make new rules. And so we are just going to strictly think about whether something is constitutional or whether it is not. And one of the most seminal cases on judicial activism versus judicial restraint happened in the early 1960s. And that is the case of Baker versus Carr. And so what happens is that Baker is a resident of Shelby County, Tennessee. He was actually the former mayor of a town outside of Memphis, which is in this area right over here. And he says that, look, the state is not reapportioning its legislative districts the way it should be. That in general, every 10 years, there is a census, and based on that, we have an understanding of where the population sits, and then the state should be reapportioning districts based on population. But what Baker argued is that the state of Tennessee actually did not redistrict since 1901, after the census of 1900. And it was now the early 1960s. And he says because of that, and he invoked the 14th Amendment, you weren't getting equal protection. That people in his county that had gotten increasingly urban and had gotten increasingly dense over the course of those 60 years, that they were getting the same representation despite having a larger population than some of the rural areas where they have a lower population and had the same number of representatives. And so he takes this case against the Secretary of State of Tennessee at the time, who was Carr, and it eventually gets to the Supreme Court. And the essential question in Baker versus Carr is whether the courts even have jurisdiction over legislative districting, because the districting was a power of the state legislature in Tennessee. And in this case, the United States Supreme Court actually did vote in favor of Baker. So not only did they say that Baker was right in asking for this redistricting, it had huge implications in saying that yes, courts like the United States Supreme Court do have jurisdiction over something that was officially a legislative duty, telling the legislative that, look, you've got to do this, because by not doing this action, by exercising your discretion there, you might not be allowing everyone to have equal protection. Many have argued, including the two dissenters to the opinion, that this was a form of judicial activism. It increased the power of the judiciary. And to appreciate the view of the United States Supreme Court that they do have jurisdiction over legislative districting, here is part of Associate Justice Douglas's concurring opinion. Where the performance of a duty is left to the discretion and good judgment of an executive officer, the judiciary will not compel the exercise of his discretion one way or the other, for to do so would be to take over the office. So he's saying, look, when it is someone's job, where there's an executive officer to do this duty, then the courts should not have jurisdiction there. But then he goes on to write, there is no doubt that the federal courts have jurisdiction of controversies concerning voting rights. The Civil Rights Act gives them authority to redress the deprivation under color of any state law of any right, privilege, or immunity secured by the Constitution of the United States or by any act of Congress providing for equal rights of citizens. Really saying that, look, if the court can see that some right is being violated, some right that's described in any under the state law, under the United States Constitution, then the courts do have jurisdiction. The right to vote in both federal and state elections was protected by the judiciary long before that right received the explicit protection it is now accorded. So he's saying, look, even before the Civil Rights Act, even before the 14th Amendment, that this was something that was part of the charter of the judiciary, part of the federal court system. And so it does lean in favor of judicial activism, because you can imagine courts, and they have cited Baker versus Carr since the 1960s repeatedly as reason saying, hey, look, we're trying to protect people's rights, and people have a right to do X, Y, or Z, even if it hasn't been explicitly legislated. Now, there were two dissenters, and this is what the dissenters wrote. The court's authority possessed neither of the purse nor the sword. So here the purse, that's the legislative branch that can think about budgets, or the sword, that's the executive branch, the president's the commander-in-chief, ultimately rests on sustained public confidence in its moral sanction. Let me underline that. On sustained public confidence in its moral sanction. Such feeling must be nourished by the court's complete detachment, in fact and in appearance, from political entanglements, and by abstention from injecting itself into the clash of political forces in political settlements. So here, Associate Justice Frankfurter, in his dissenting opinion, is saying, look, we should stay out of this. That not only is it not our part to rule here, to say that, hey, look, the legislative needs to do this redistricting again, he's saying that it actually undermines the credibility of the court, that the credibility ultimately rests on sustained public confidence in its moral sanction. And that by ruling in favor of Baker, the court was overstepping these bounds. That people would say, hey, you're trying to legislate from the bench. You're trying to get involved in the political, even though the court is supposed to stay above the fray of the political. Or another way to think about this is that Associate Justice Frankfurter subscribed to the idea of judicial restraint and felt that the other 6 justices that were voting in favor of Baker were practicing to some degree judicial activism. They were getting into the territory of the other branches of government.
Okay, so I like this video just because it goes over a really good case and then gives you the example of what does judicial activism look like versus judicial restraint. And it's going to be case by case depending where judges kind of go, because sometimes they're doing something unprecedented. They're changing something and they're interpreting something that hasn't really been done before and stuff. And sometimes they have the right to do that, sometimes they don't. Judicial restraint, respecting that this is in my lane and I don't have a right to overstep it. That's a law that needs to be changed. That isn't the role of this court. And both can be appropriate. It really depends on the court case. But that's why it's good to have the popular opinion and then the dissenting opinion to see why are they justifying their place and their decisions. Okay, let's go over the answers really quick and then we'll wrap up. What is the difference between judicial activism and judicial restraint? So I put this in the chat and I'll put it there again. Okay. So this is the first one. Judicial activism is where the courts make rulings in order to affect society to make changes. Restraint is the courts leaving the actions up to the state or the government to deal with, okay? So saying this isn't our right to interfere doesn't mean a change doesn't need to happen, but this isn't our place to make the change. This needs to happen in the state's legislative or the federal government legislative, okay? So saying that's not our role. This is outside of our checks and balance responsibility. And not all judges agree. That's why you have multiple judges and that give difference of opinions, okay? Is it possible to apply neither judicial activism or judicial restraint? I don't think so. I don't think it's impossible to do. I don't think it's possible to not do either. I think you're always either looking for change and justifying your action as a judge, or you're looking and saying, no, this is clearly not a decision that the courts have the authority to be making. So I think really in pretty much all cases, judges are either doing judicial activism or judicial restraint. I don't think you can really avoid one or the other. You're either declaring this isn't our job or something we're allowed to do and putting it back to the states, or won't rule on it, or you are making a decision based on interpretation that could affect society, Okay, give me a thumbs up once you have this. How are we doing? Awesome, awesome. So make sure this is saved to your government drive, okay, on the Google, or your government folder on the Google Drive, okay? So we went over the supporting question, key vocab, what does constitutional interpretation mean, and judicial discretion, and really quickly, activism versus restraint. So tomorrow we'll open up again and we'll review again what is activism versus restraint, okay? And then we'll continue on looking at those court cases and stuff and how the courts use them, all right? So we went over supported question, vocab, constitutional interpretation. If you haven't already, go ahead and delete 8 and 9 from your notebook. So go ahead if you haven't already. And you can delete 8 and 9 from your notebook. So you can take, 7 and 8. Sorry, 7 and 8. I didn't realize that there was no 9. Okay, 7 and 8. So make that 7 and 8. Go ahead and delete those from your notebook. Okay? That's it for today. You are free to go, and I will see you on Thursday, right? Period 2, I'll see you on Thursday. Thank you so much. Y'all are awesome. Bye. Thank you, Catherine.